So let's look at a case. State v. Watson. Now, officers from Clayton PD received a tip from a confidential informant that the defendant had retrieved some suspicious packages from a local UPS store. Well, suspicious packages, we're going to talk more about that. But let's first talk about our CI. The informant was a UPS employee trained to detect narcotic shipments. He noticed the packages had a Utah return address when they had in fact been shipped from Arizona. The employee had previously provided tips to law enforcement that had led to the arrest and conviction of individuals for drug offenses. Okay, you guys know I'm going to go off topic. Whenever you talk about a CI, particularly when you get ready to do a search warrant, remember you need to discuss the reasons why the CI is deemed credible. And that gets into things like past experience, prior cases that may have resulted in arrest and, more importantly, convictions, whether or not the CI was a witness to the criminal activity or is providing information that could subject them to criminal prosecution. Remember, you always have to establish the basis for the CI's knowledge and why you can have confidence in the information being provided. All right, back to the lesson plan. After receiving the tip, officers arrived at the UPS store, observed the defendant driving away, and initiated a traffic stop. During the stop, the officers conducted a canine sniff, which led to the discovery of drugs inside the packages. Now, everybody agrees that when the officers initiated the traffic stop, they seized the defendant. However, the question before the court was, did the officers have reasonable suspicion to seize him when they initiated that traffic stop? So what do you think? Well, the court agreed with the defendant. There was no reasonable suspicion justifying the stop, and that the found drugs should therefore be excluded from evidence. The court pointed out the only factor in the reasonable suspicion analysis was the mismatch between the return address and the actual shipping address, which in and of itself is not illegal, and there was no case wherein a court has determined the existence of reasonable suspicion based solely on a suspicious return address. Now, the court then went on to talk about other factors which, if they had been present, would have contributed toward finding reasonable suspicion, and it did this based on existing cases. One, the size and shape of the mailing, whether the package is taped to seal all openings to try to basically make it airtight, whether the mailing labels are handwritten, whether the return address is not merely a mismatch, but did they know that it was fictitious, unusual odors coming from the package that might be used to mask drugs, city of origin being a common drug source locale, and repeated mailings involving the same sender and recipient. The court noted that none of these factors had been articulated, and therefore there was insufficient basis for reasonable suspicion. As to the informant's tip, the court stated that an informant's tip can provide reasonable suspicion if the supplied information reasonably describes both the suspect and establishes criminal activity. Here, you had one of the two. The tip reasonably, reliably established the suspect, but not establish criminal activity, and therefore did not add anything to that reasonable suspicion analysis. Court said, reasonable suspicion requires the tip be reliable in its assertion of illegality, not just in its tendency to identify a person, a determinable person. So, what could we have done here? Well, if the UPS employee felt they had a suspicious package and it was within the custody of UPS, they could have allowed law enforcement to bring in a canine, sniff the package, and then if the animal alerted, then you would have had that probable cause to believe criminal activity was present, drugs were located in the package. Then either they could have searched it further or let the recipient pick it up and stop him as he is departing. And then you would have had a good stop. So there's just another way to try to get here. But there's also other things that they could have looked for. Whether or not they were present is unknown. Alright, so here we go. Anaheim, California. Knock and talk. Now, as you know, and we've been discussing up till now, the Fourth Amendment. And that applies when law enforcement intrudes somewhere that people have a reasonable expectation of privacy. Knock and talks are not normally considered a search. I say normally because you will remember the Florida case where officers took the canine to the front door of a house where they didn't think anybody was there to do a knock and talk and let the dog sniff the doorway. And that was just a bit too far for the Supreme Court. But the honest-to-God knock and talk going up to the front door, as you've heard me say before, cops are people too. And just as anyone else can go to the front door of a residence, knock, wait to be received, so can law enforcement for a law enforcement purpose. Now, the Supreme Court refers to that as an implied license, an implied permission for visitors to come up. To be honest, that's true even when they say no trespassing, because it's a license for a verifiable, a bona fide purpose. Now, as you will also remember, when you operate under that implied license, you are going to the front door, or if it appears that the side door is the one most commonly in use, to go there. It is not a license to go wander around the house or even on the front porch trying to look in the windows to see what you can see. Now let's take a look at the case of State v. Huddy. Now, what you see here is that around 11 a.m., deputy patrolling an area that was known to be at risk of home invasions and break-ins. He approached Huddy's home and saw a parked vehicle with its doors open at the end of a 150-yard driveway leading to the rear of the home. The deputy thought that was unusual, so they ran the tag. And the information, the registration information, came back to a different address than the house where it was parked. And as he observes this, he sees that the front door was covered in cobwebs. Did not appear to be used as the main entrance. So he did not knock on that front door, but he also did not observe any signs of a forced entry on that front door. So he then cleared the sides of the home before walking to the back of the house, under the theory that he was looking for the actual entrance to the residence. Now, as he goes around the sides, he comes to the backyard, which is enclosed with a chain link fence and gate, which was closed. Opens the chain link and then approaches the storm door on the enclosed rear porch. Now, this was not visible from the street, and as he approached the storm door, he immediately smells marijuana in the area, in the vicinity of that storm door. At this point, the officer left without identifying his presence and obtained a search warrant. Upon returning to execute the search warrant, he seized a large quantity of marijuana. Huddy was charged for possession with intent to sell or distribute. Huddy moved to suppress the marijuana, alleging an Fourth Amendment intrusion in an area with a reasonable expectation of privacy by coming into that backyard. So what do you think? Well, there were two issues raised by the state. One was the idea that this was a simple knock and talk, and the other being the community caretaking. So I'm going to give you a second just to think on each of those, to include, do you see the application of community caretaking to this fact pattern? Now, of course, the idea of the knock and talk gets you to the front door, or what appears to be that main entrance. And the court here found that the deputy had exceeded the scope of the knock and talk and violated the Fourth Amendment. He ran the tag of a car which was not visible from the street, so he'd entered onto the protected premises, and it's one thing to knock on a door, it's another thing to run a tag. He checked windows for signs of a break-in and then walked around the entire home before approaching the back door. That really is more than just going up to that front door, or even what appears to be the main entrance, and knocking and waiting. So then we have community caretaker, and the court held that the observation of that vehicle with open doors did not justify a search based on community caretaker, and noted that no North Carolina case had ever applied the community caretaker doctrine to the search of a home. And in fact, for caretaker purposes, they said the deputy could have just knocked on the front door or called out to see if anyone needed assistance, and then waited to see what type of response they received. So, in this case, the evidence was suppressed. So, searches. A search of a person or property, or seizure of property or person, to be constitutional must be reasonable under the Fourth Amendment. Now, as we've already discussed, when you talk about searches and seizures under the Fourth Amendment, we have two basic standards. One, which is reasonable suspicion, leading to an investigatory detention. And that's typically used to seize a person and hold them while you try to determine if you have probable cause that criminal activity is actually present that will lead either to arrest or a search. And then again, we go back to probable cause, and probable cause is the standard set forth in the Fourth Amendment, which is to say a probability that the object sought for will be found in the place to be searched. And that when you have probable cause, you can go before a neutral and attached magistrate and obtain a search warrant. Now, there are those examples and situations which we're about to discuss where you can conduct a search with probable cause, but for when you do not have a warrant based on some exigency. And the first of those that we're going to talk about is the protective sweep. And the protective sweep is done at time of arrest, typically in homes, when you have some reasonable suspicion. Here they listed as a reasonable belief, based on specific articulable facts, just as you otherwise need for reasonable suspicion, that there is a person posing a threat to those on the arrest scene, that there's some other person who presents a threat to the officers, and that lets you conduct a protective sweep in the residence for that person, so you're looking in places that could contain a person, and as soon as you're done with that, you are done. You are not looking for evidence. Yes, you may see something incriminating. If so, you can identify that for purposes of securing the residence and getting a search warrant. But the idea of the protective sweep, it is brief. You're looking for people, and as soon as you know there ain't none there, you are done. Now, our second one, exigent circumstances. And more than the protective sweep, which is based on reasonable suspicion, exigent circumstances are still based on probable cause, but they're an exception to the warrant requirement. And that's looking for contraband or evidence of a crime that is present. Now, when we talk about there's an exigency that prevents you from getting a search warrant, you've got to look at, one, the degree of urgency involved and the time necessary to obtain a warrant. Not just merely that it's inconvenient, but what's the urgency driving the issue to search now? That can be an objective belief, a reasonable belief, that contraband or evidence is about to be removed or destroyed. The possibility of danger to police guarding or securing the site while somebody goes to obtain a search warrant. And similarly, the inability to properly secure the site. Information indicating the possessors of the contraband or evidence or where police are on their trail, and how readily destructible or movable the contraband is. So let's take a quick look. Okay, maybe not so quick. At the case of State v. Marrero. Now, in the case of State Marrero, the facts are going to be a little interesting. This starts with an officer receiving a tip from a CI that a home invasion robbery was going to take place at a house near Milton Road. And the CI explained that he knew about the plan because he had turned down an offer to participate in it. but he was able to identify the residents, explain that the target house had a red pickup truck in the driveway, and that the robbers had attempted to obtain an AK-47 and would be coming in a small red Hyundai. Officer confirmed the information was reliable and dispatched other officers to monitor the location. Now, while the officers were monitoring the house, they observed a small red Hyundai drive past the residence twice. Now, the reason for the home invasion robbery was that at this residence they were conducting a marijuana grow operation. So, despite that threat, detectives were dispatched to do a knock and talk on the residence to investigate drug activity. The officers on scene were instructed to continue monitoring the house in case the robbers appeared. So the two detectives there to do a simple knock and talk arrive in tactical vests with police written on them and approached the front porch. At that time, they did not know whether the robbery had already occurred, was in progress, or had not yet occurred. Defendant observed no blue lights during the encounter. The other officers monitoring the situation were located at the end of the driveway, in the backyard, and at the back right corner of the house. Two other officers were in the front of the house, with shotguns in the low ready position. Now, one of the detectives shined his flashlight into the windows on either side of the front door and then knocked. In response to a muffled voice, he announced, "Charlotte Mecklenburg Police Department." The detective knocked again, and a few moments later, the defendant opened the door. Now, as soon as the door was opened, the detective smelled green marijuana, and also realized that the defendant did not speak English. So he was detained. The detectives, based on the possible home invasion robbery, as well as the ongoing criminal activity involving a marijuana grow operation, performed a protective sweep of the residence and then applied for a search warrant, which resulted in the seizure of 30 pounds of marijuana. Not surprisingly, the defendant moved to suppress the evidence. Now, the first issue was this a proper knock and talk? And even if it was the defendant coerced into opening the front door? And the court held that the knock and talk was proper, and there was no coercion. The fact that two officers walked up to the front door to perform the knock and talk, there were no takedown lights, no blue lights activated, nothing that screamed law enforcement presence or arrest. And defendant apparently was not even aware of the police presence until he opened the door. So there had not been a seizure. The court also found there were exigent circumstances for the warrantless entry into the house, given that at the time they conducted the knock and talk, they did not know whether the robbery had occurred or not, or in fact might have been ongoing, and that the CI had stated that the robbers might be armed with an AK-47. Further, as soon as the door was opened, the officer smelled that green marijuana. It was obvious to them, giving probable cause, and we're going to talk about more about plain smell in a moment, probable cause that evidence was there, evidence that could have been destroyed. So the court concluded that the police officers' need to ensure no one remained in the residence armed constituted an exigent circumstance, and the detective's belief that the defendant could and would destroy the marijuana if they left to obtain a search warrant also constituted an exigent circumstance. But really, since they did get the search warrant, this was not applied in this case. So you got a quick quiz.